The next matter to come before the court this morning is State of Ohio versus Sebastian Fleckenstein. We are a couple of minutes early. Is there any objection to beginning this oral argument a little earlier than scheduled?
Not on behalf of the.
No, Your Honor. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. I'm keeping the clock today, so if you let me know when you get started, I can let you know if you're reaching into any reserved time. The judges have read the briefs. We are ready to proceed, but let me just mention, please don't use the names of any victims or minors as we are recording this oral argument when we post it on the court's YouTube channel. Thank you. We're ready to proceed when you are.
Yeah, I apologize, but I have a clarification question. There's two briefs. Is there 15 minutes on each argument?
Oh, thank you for asking. That's true, there is a cross appeal in this case. What will happen is as the appellant, you will utilize your 15 minutes and you will have any time for rebuttal. Then the appellee must utilize its 15 minutes completely, so there'll be no rebuttal by the appellee. So if you wish to argue a defense to the state's cross appeal, you need to do that either in your initial time or part of your rebuttal time.
Okay, so it's still 15 minutes.
Yeah, precisely, yes, yes.
Thank
And would you like to reserve any time for rebuttal?
3 minutes.
Sure. We're ready when you are.
Thank you, Your Honor. Your Honors. I was once trying a case over neighboring Cuyahoga County, and I've been a prosecutor. I've been practicing over 30 years, I think over 35, December '86. I've been a county prosecutor for 10 years. So I'm pre-trying this case. I've got the indictment, and I've got my police reports, and I'm looking them up, and I said, look, there's one crime here. Why do I have like whatever it was, a 2-3 count indictment? Because count 2 is simply a lesser of count 1. But, you know, there's no basis for a separate charge. And case worked out, so it wasn't an appellate issue. It worked out with the plea. So I asked the prosecutor, so why is that? He said, well, he didn't name the judge, but that's irrelevant. He says there's a certain judge who we regard as being too stingy on giving instructions on lesser included offenses, so this allows us to end run the judiciary. So I know why it was done in Cuyahoga County. I don't know why in Lorain, and I'm not pointing fingers because intent's irrelevant. I mean, I could just see a prosecutor, what charge kind of fits, and everything gets indicted. But more, it's not intent, it's the net result. And here we just had a trial that was a complete mess because the defense trial counsel, who I know, respect, listen to, take advice from, and the judge, who I know from Cuyahoga, actually worked out here with him a little bit, who I know and respect. Nobody said a word about lesser included offenses, and we're talking about 2 shots and 1 bullet striking somebody. When a jury is instructed on a lesser included offense, they're told, 1, when they may start considering a lesser included, and then they're also told, 2, once you get the guilty, you stop. You don't keep going and looking for lessers. Because, yeah, you could find them guilty of disorderly conduct. Shooting somebody is alarming behavior. That was totally absent. And now, with the cross appeal, the 3-year gun, that makes the 3-year gun spec relevant. The felonious assault that they want a 3-year gun spec to attach to should have, 1, it should have never gone to the jury. And because, I mean, they're saying it's just a merged offense, they're following Boulder, oh, this is merged. My argument is it shouldn't have been a conviction to begin with. It should have never gone to the jury. I mean, you find somebody guilty of a homicide and you're going to deliberate felonious? parties told the jury in opening, you know, this is a case of either it's murder or it's self-defense. And so to allow a murder B instruction is to invite the compromise that lesser included offense law is supposed to prevent. And that's what happened here. And again, I think it's, not sure if I emphasized it enough in my brief as I looked it back over preparing for today, but my client's application of force directly caused the decedent's death. And to say that my client's application of force proximately caused the decedent's death is like silly. And it's like finding John Wilkes Booth guilty of involuntary manslaughter because he committed a crime. He trespassed into a private booth balcony, and as an approximate result of committing that crime, Lincoln's dead. So the problem with the convictions here is the notion that, and again, all the self-defense law, you are using force to directly cause death. It's like an admission. So to say that it's, I mean, it sounds nicer, and here's the jury's compromise. Well, he only committed a felonious that happened to cause death. It sounds nicer. So rather than self-defense, because we didn't find him guilty of murder, we'll find him guilty of murder B. And of course, the prosecutor's happy because they both carried a 15 to life sentence. But it's something that simply does not belong. The weapons disability, and I can't help but think that also really threw a wrench into the works here. And again, which is why there's an ineffective assistance of counsel claim. Self-defense is applicable to a weapons while under disability charge, albeit under limited circumstances. But those limited circumstances fit here. We only know that there was a gun on the porch nearby and that it was picked up and used. We don't know whose gun it was. We do know the defendant disposed of it, but that doesn't mean it was his. I cite the Frederick Douglass example in my brief. Yeah, he stood his ground, but fortunately he didn't stand his ground and wait for the police because he wasn't going to trust them. So he did what he did. But it doesn't change what looks to be a very strong self-defense case. He's on his porch on a Friday night at midnight or thereabouts, minding his own business when this happens. Doesn't know the guy. He's a stranger. In the third assignment, I talk about insufficiency of the involuntary manslaughter and discharge over a road because the two detectives says, look, we don't see anybody in this video, so we don't know where this guy was when he was shot. And the coroner said he could have lived for seconds up to minutes after being shot. He had to bleed out. So we really don't know. As I put in my brief, it's a 1 in 4 guess where he was. And furthermore, the discharge near a roadway doesn't apply. It says it's illegal to do that, and if you cause serious physical harm, here's the penalty. My client didn't cause serious physical harm, he caused death. And the reason why death is not included And that charge is because you charged the guy with murder.
And counsel, I know it's difficult, but if you could remain as close to the podium as possible, because these are being recorded, and each time you wander off, we have a voice, but no.
Thank you.
It's
Okay. I had a chuckle to myself when I'm reading the transcript and one of the prosecutors say, it tells the jury, as he had to, I don't know what else he would have said, he said, when he got to this portion of the case, he tells the jury, well, death is sort of a type of serious physical harm. Well, no, it's not. There's a clear distinction. You have physical harm, you have serious physical harm, a lot of argument where one of those ends and the other begins, but death is complete. It's not really a type of serious physical harm. Could you imagine trying to offer condolences to a loved one who's had a family member who was murdered, and you say to them, I'm sorry for this type of serious physical harm that happened to your loved one. The charge didn't even belong. And without reaching for my notes, I think that's all I have for now.
Okay, thank you, counsel. You'll have a full 5 minutes for rebuttal if you please.
All right, thank you.
May it please the court. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the state. Sebastian Fleckenstein was convicted of multiple counts in the shooting death of a male victim which occurred in the middle of Apple Avenue just before midnight in July of 2021. On appeal, Fleckenstein has failed to demonstrate that there is any reason for this court to disturb those convictions. Surveillance video footage captured the shooting to which Fleckenstein confessed. In an audio and video recorded interview with law enforcement, Fleckenstein made statements admitting to shooting the victim, who he admitted he had never met, was unarmed, and uttered no threats against him, including that he fired both gunshots, the first of which killed the victim, and the second of which he shot in the air. The two gunshots were separated by 9 seconds, and after firing, Fleckenstein admittedly fled the scene. As a result, Fleckenstein was indicted on 11 counts. I'm going to try to track the assignments of error in the appellant's brief to try to give some structure to my argument. And the first assigned error is basically that the executive branch returned a defective indictment, which then affected the jury instructions as the jury was told to consider each offense discreetly and separately. And the problem with these arguments is that Fleckenstein did not raise them below, and this failure proves fatal to both of his claims. Objections based on defects in the indictment must be raised below, and if they are not, they are subject to a plain error review. And likewise, trial counsel raised no objection to the manner in which the jury was instructed to consider all matters separate and distinctly. Fleckenstein conceded that point in his brief, and he has failed to argue plain error in his brief, and those failures are fatal, like I said, because this court has repeatedly made clear that when an appellant does not develop a plain error argument in his brief, this court will not create one on his behalf. The second assigned error is that the trial court erred when it failed to give a self-defense instruction with regard to his weapons under disability count. And that argument should be rejected for the same reasons as the first. The record indicates that prior to trial court instructing the jury on self-defense, the court, Fleckenstein, and the state exchanged, reviewed, and discussed jury instructions that were ultimately provided to the jury. Those instructions did not include a self-defense instruction as to count 10, weapons under disability. Fleckenstein, however, did not propose a self-instruction for having weapons while under disability at that time or object to the lack of its inclusion. The trial court ultimately instructed the jury on self-defense as to count 1 through 7, but Fleckenstein did not object to the self-defense instruction that was provided to the jury. Again, that failure precludes this court's review for anything other than plain error. He has not argued plain error in his brief, and this court should not develop a plain error argument on his behalf. Fleckenstein's third assignment of error is in regard to the sufficiency of the evidence for his involuntary manslaughter and discharging convictions. Here the state was essentially required to prove that Fleckenstein had a gun, that he fired it over a public road, and that this conduct resulted in the death of the victim. Here the state met its burden. The state presented sufficient evidence to establish that the first bullet that Fleckenstein admittedly fired traveled over Apple Avenue, a public roadway, before striking the victim, who had just exited his car, thus causing his death. Testimony and evidence presented at trial showed that Fleckenstein fired the gun from the area of a porch on East 23rd Street. The residence was located on the southwest corner of East 23rd Street and Apple Avenue. The porch faced Apple Avenue. The victim, who was still standing in the street, as confirmed by the surveillance video footage, which was played for the jury multiple times, was struck by the first fired shot and immediately fell to the ground, which was demonstrated by the illuminated light on the open car door, which he had just exited seconds before, and where the surveillance camera was positioned. Surveillance cameras then showed the footage, then showed two figures, one of whom was determined to be Fleckenstein by his own admission, running from the porch area of the East 23rd Street residence past the vehicle and where the victim's dead body was laying in the street. First responders then found the deceased body laying in the street in the same area where the victim had exited his car just seconds before, and coroner testimony revealed that the victim's knees had abrasions, indicating that he fell in the street just immediately before being struck by that first shot. These abrasions were consistent with the victim having fallen in the street. These photographs of the victim's knees and the abrasions were illustrated in photographs and shown to the jury. And viewing this evidence in the light most favorable to the state, as this court must, there was evidence, sufficient evidence adduced at trial that the bullet traveled over the public road before striking the victim, lodging in his body and killing him. And as to the fourth assignment of error, the jury rightfully rejected Fleckenstein's assertion of self-defense. The state met its burden in persuading the jury beyond a reasonable doubt that Fleckenstein was not acting in self-defense when he shot and killed the victim. The state was required to only disprove one element of self-defense beyond a reasonable doubt to adequately disprove Fleckenstein's claim of self-defense. And here the weight of the evidence supports the jury's determination that Fleckenstein did not act in self-defense. Here not only was Fleckenstein the initial aggressor, but he had no reasonable grounds to believe that he was in imminent danger. He was at fault in creating the affray as he escalated the situation by retrieving a firearm and shooting at the unarmed victim in the street after mere seconds. He was sitting on the porch again with a loaded 9mm handgun in reach, a firearm he was prohibited from possessing after the victim stopped his vehicle in the middle of Apple Avenue. He admitted that he did not see the victim with a gun or hear the victim utter any threats before him, and subsequently escalated the situation by firing 2 shots, the first of which struck and killed the victim. He also had no reasonable grounds to believe or have an honest belief that he was in imminent danger. He points to his own self-serving statement that he was terrified. But the surveillance video, which was played for the jury multiple times, dispels any notion that the victim came at the porch or left the street. And Fleckenstein's own actions after the shooting also indicate that he did not have an honest belief that he was in imminent danger. Text messages and a TikTok video from the forensic extraction that was done on Fleckenstein's phone show that for days after the shooting, Fleckenstein bragged about shooting and killing the victim. Here the victim was unarmed. Fleckenstein admitted as much in his interview with law enforcement. No weapon was located on the victim's person or in the vehicle. Despite knowing that, Fleckenstein escalated the situation, shot at the victim from the porch, and killed him. Based on the record in its entirety, this court should conclude that the jury did not clearly lose its way. While Fleckenstein's convictions must stand, the state has cross-appealed and submits that the trial court's sentence is contrary to law because it failed to impose prison terms for the two most serious firearm specifications.
Are aggravated murder sentences reviewable on appeal? Didn't you just say that earlier that they're not?
This is not an aggravated murder
Or
conviction.
should be just a murder conviction?
Murder.
All right.
Correct. Both in its sentencing memorandum and at sentencing, the state explicitly requested that the trial court impose prison terms on at least two of the firearm specifications attached to Fleckenstein's convictions. The trial court denied that request and only imposed a prison term for a 3-year specification attached to Fleckenstein's conviction for murder in count 3. But the statute regarding firearm specifications in this situation applies whenever an offender has been found both guilty of multiple felony offenses, and at least one of those felonies is enumerated in the statute, and multiple firearm specifications. Here, Fleckenstein was found guilty of both murder and felonious assault, both of which carried 3-year firearm specifications, and both murder and felonious assault are enumerated felonies. According to the plain language of the statute and controlling Ohio Supreme Court precedent in Bolar, he must receive prison terms for the two most serious specifications to which he was found guilty, which were 3-year firearm specs. The state requests ultimately that Fleckenstein's convictions be affirmed and that its own assignment of error on the cross appeal be sustained so that a resentencing may occur on the firearm specs. Thank you.
Thank you, counsel. Attorney Corrigan, you have 5 minutes for rebuttal.
Thank you. A few factual clarifications that I think need to be made. My client, there was no gun recovered near the victim, but part of my client's statement was that he thought the guy was going for a gun. And again, we have this strange, frankly idiotic, bizarre behavior with no reason, and my client and his stepfather the only one out there. And of course, it always creates controversy, but we have a lot of police shootings where the suspect doesn't have a gun and everybody's in an uproar, but they're ignoring the reasons why the police shot, which is it looked like he was reaching for a gun and a whole host of other circumstances that sometimes, yes, unarmed people get shot. And again, I hope my brief is clear, but I think the facts are very clear that we don't know that the victim was shot while in the roadway. The two detectives said they can't see anybody. The coroner said after the bullet struck, it was less than instantaneous fatal. He had to bleed out, so therefore he lived for, well, it took a couple couple seconds to a couple minutes for him to pass out. Now, both sides, the great advocates both for the parties, try to be some Zapruder film experts and demonstrate that this dark film proved their case, but it simply didn't. And in addition, we don't have serious physical harm here. We have death, and it's a material distinction. That charge was never intended for a case involving a direct murder. Or at least not a finding that there was serious physical harm. The finding was death. The only finding. The state's absolutely right that in terms of self-defense, the law states that they only need to disprove one element. And that's where I look at the faulty weapons while under disability charge. I mean, the jury was told, if you think he had a gun, of course it's a shooting, and there's no denial of that, it was unlawful for him to pick it up. So, of course, they're going to say, the problem's all his to begin with. There goes his self-defense. I think the weapons disability misinstruction is a key part of why there was no self-defense. Bowler, I hope I have the courage to say it in Columbus, because I know that's where it comes from, but Bowler is silly. Even the prosecutors in their briefing to the trial court, when Bowler didn't exist yet, completely agreed that you can't get a gun spec off a merged charge. And the whole reason of that is it's constitutional protection against finding somebody guilty of the same conduct twice. And also, it dawned on me this morning that I mean, there's law out there saying one cannot appeal on a merged offense because there's no final appealable order, yet we can have gun specs.
Well, the gun specification, isn't there a separate finding of guilt for the specification?
Pardon?
There's a separate finding of guilt for the specification in conjunction with the offense, correct? There's
Right, but they're looking, I'm referring to the second gun spec charge that feeds off
the merged count.
a merged count. And all I can say is it's silly, but I can distinguish Bowler. And what the state is doing is expanding Bowler, saying they call it merged offense. I'm calling it lesser included offenses that never should have been there to begin with. So it's a 3-year gun spec. They're looking for a conviction that should have never taken place. And lastly, there are a lot of appellate rules out there that hurt my cause. But ultimately, you are looking at due process, you are looking at fairness of the trial, and I couched my first assignment in the air in terms of separation of powers. I don't know how many books you've read where everything's a violation of due process. You can ignore it. But here we have a series of charges.
I need to let you know you have utilized your time available on rebuttal, so if you'd like to just sum up in a sentence.
Yeah. We have a series of charges, no judicial scrutiny, no defense scrutiny, results in an unfair trial. Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which is mailed to all parties to this appeal by the clerk of courts on the day that it is issued. It will also be posted on the Ohio Supreme Court website. Thank you again.
Thank you.